MacLaren Hall was a notoriously violent, cruel, and abusive institution for children located in El Monte, California, which is part of Los Angeles County. In 2003, it closed in disgrace, and some of its former inhabitants began speaking out about sexual abuse at the facility. Although initially intended for minors without criminal backgrounds, Mac Hall, as it was informally called, is said to have felt like a jail. It had a 14-foot chain-link fence, topped with 5 feet of barbed wire, surrounded by floodlights. For decades, up until the 1970s, the county probation department ran Mac Hall, and they operated it just like they operated the prisons. Children frequently ran away, violence was common, and the facility was notoriously overcrowded. Many reports by former residents of overmedication, beatings, restraints, confinement to a small punishment room, rape, and other forms of sexual assault make Mac Hall a supposedly dangerous and traumatizing place to have been, versus the sanctuary it was intended to be. We're going to answer several questions for those who may have suffered abuse at MacLaren Hall. The most important of which is, do you have a case? If you win, how much compensation can you receive? And how much time do you have to file a lawsuit? Dogged by child abuse and neglect complaints, Mac Hall finally shut down when the American Civil Liberties Union, or ACLU, sued Los Angeles County for failing to provide sufficient medical care for the children. In its lawsuit, the ACLU accused Los Angeles County and the state of California of several broad failures, many of which directly involved Mac Hall, including over-reliance on Mac Hall as a semi-permanent rather than temporary housing facility, favoring budget-conscious decisions over those in the best interests of the children, merely cataloging the mental health needs of children rather than focusing on providing the requisite care. Children in need of mental health treatment or with other special needs either received no appropriate treatment or minimal treatment only 1 hour a week. And finally, the ACLU uncovered a lack of training for Mac Hall staff and other social workers. The first issue we'd like to address is the question of whether Los Angeles County can be held liable for sexual abuse at MacLaren Hall. The answer is yes. There are many legal theories by which Los Angeles County can be responsible for sexual abuse, physical abuse, and other mistreatment of children at Mac Hall. Likely the most promising is negligent hiring and lack of supervision. Los Angeles County, as the employer, knew or should have known that Mac Hall staff members were a risk to the residents at the facility. The county may be responsible for sexual abuse that occurred at the hands of Mac Hall employees if one or more of the following applies. 1. The county fails to run a background check and hires a person who has a criminal record for assault. 2. The county ignores complaints by parents of a staff member's inappropriate behavior, or it ignores other evidence of abuse. 3. Overlooking signs or reports of abuse only one time can be deemed negligent. And 4. The county writes a training program for its employees about child sexual abuse, but fails to supervise its employees' implementation of related protocols. If you have been a victim of sexual abuse or neglect at MacLaren Hall, you may be asking yourself, how much compensation can I receive? Well, there's no exact formula for determining the amount of compensation a jury might award a victim of child sexual abuse. Each case is different, and the dollar number awarded depends on the specific facts of your case, the evidence presented, and the jury itself. Compensation can cover past, present, and ongoing medical expenses, including psychological and psychiatric treatment, pain and suffering, and other damages resulting from your harm. You may also be wondering, how do I know if I have a valid case? Victims of sexual abuse at Mac Hall can prove negligent hiring or supervision if they can establish the following 4 elements. 1. The employee was unfit to carry out the job duties needed to fulfill their responsibilities at the center per their hiring contract or job description. 2. Los Angeles County knew or should have known that the employee was incompetent or worse. 3. The employee sexually abused a resident. And 4. The sexual abuse resulted in physical or emotional damages to the resident. And the final question you may be asking yourself is it too late to file a claim? Probably not. Under California law, if you were a child when the sexual abuse happened, you have until the age of 40 to sue Los Angeles County for the harm you suffered from the staff at Mac Hall. This time restriction is called a statute of limitations. There are 2 exceptions to this rule, one permanent and one temporary, that can prolong the time you have to initiate a lawsuit. But the statute of limitations, while seemingly straightforward, can be complicated. You will need the help of a lawyer experienced in sexual abuse lawsuits to help you determine if you have a case. If you experienced sexual assault or neglect at MacLaren Hall, please consult with our legal team to examine the facts of your case and determine whether filing your sexual abuse claim is still an option. Please do not hesitate to reach out to us to arrange a free consultation. We hope this video has helped you in some way begin your journey to justice if you have been abused at MacLaren Hall.